Good afternoon and hello to everyone out there. Welcome to WG University, Weber Gallagher's series of educational programs. This is our workers' compensation webinar series. I'm Lucas Shovelock and I'm presenting today with Jeff Seifert from our Philadelphia office. Each month we present current topics in workers' compensation legal issues. We present both case updates and ways to manage risk in your businesses. If you would like to view this webinar again, share with others, or see other WG University programs, please visit the Weber Gallagher website, www.wglaw.com, and you'll find copies of this presentation and others under the WG University page. Also, feel free to contact the firm with any questions at questions@wglaw.com. Today's presentation is Defining Injuries in PA Workers' Compensation Cases. Next month, our topic will be Top 10 New Jersey Workers' Compensation Cases of 2017. Okay, now let's get started. Okay, today with discussing the topic of defining work injuries, let's start from the very beginning, specifically setting the stage and accepting an injury. As we know, the time frame for accepting or denying a work injury is within 21 days. So that's really where we're setting the stage in terms of coming up with our initial definition of injury. So of course, we have a few methods of acceptance. You have your Notice of Temporary Compensation Payable, as well as your Notice of Compensation Payable. And these are both bureau forms. And within those forms, there's a portion for injury information where you're going to specify the initial definition of the injury. You'll mention the body parts affected. So it could be leg, arm, back, lumbar spine, the type of injury and the description of injury, a little narrative about what happened.
And with the new EDI transaction in Pennsylvania, the Bureau publishes an entire list of different types of injuries and also description of injuries that your EDI department will be putting into the system in order to generate that Notice of Temporary Compensation Payable or the Notice of Compensation Payable.
And what are a few of the different ones we've seen? I know we've seen sprain strains, or tears or strains. I think with the new EDI system, as opposed to the typical sprain strain, you might see contusions, lacerations. That's fortunately not too many of the more severe injuries, at least how they define them via the EDI system. And we'll get to how that can be important in the initial definition of the work injury. So the initial definition of the injury. Often when it comes to defining work injuries, we want to look at what information we have at the onset when we're performing our initial investigation, which can be rather minimal. When someone gets injured, they might go to a clinic type of setting, say a MedExpress, a Concentra, a WorkNet, where they'll see one of your panel physicians. At that juncture, it's pretty difficult to state exactly what is going on based on their early presentation. So what we'll see in terms of diagnoses would be sprain strains, contusions, lacerations. And the main thing we have to consider is there's not a lot of information available at that time. We do not have diagnostic studies. We might not see them until a little bit later on in treatment. So we need to think of, we don't want to accept more than we want to from the onset. Is that right, Jeff?
It generally, yes, is initially because of the time limitation of accepting an injury within 21 days, you don't always have those diagnostic studies. And one of the themes of today is very much once you accept a specific type of injury, it's very hard to undo that. So generally in that first 21 days, the types of injuries that you're going to want to accept are going to be those less severe sprain strains, contusions, because you want to make sure that you have your medical professional reading a diagnostic study and giving you an unequivocal opinion that the more severe types of injuries, such as tears or herniated discs, things such as that, are related to the work injury. You don't want to accept a specific diagnosis that is not related to the work injury. Because at a later date, it is very hard to unring that bell, so to say.
And I guess one thing that we can also point out is with diagnostic studies, even if we do have them and they might reveal certain findings, that's only a snapshot at that particular time in the a claimant's life. If we see a herniation on there, there's no guarantee that that herniation was actually related to the incident at work or whether it was something that was potentially pre-existing. The same can be stated about degenerative changes that we'll see on diagnostic studies. Typically, of course, they take years to develop. There's no guarantee that that was at all affected by the incident, and sometimes by accepting sprain strain allows you to have the opportunity to get an evaluation, an independent medical evaluation, to determine if anything else happened.
And right, those diagnostic studies are just a snapshot in time, and medical experts will tell you that in order for any of the findings on a certain diagnostic study to be relevant, especially to the type of injury that you're accepting, there has to be a clinical correlation. So one of the points we want to make today is that when accepting and defining an injury initially, you want to make sure that that definition isn't coming from the interpretation of just a diagnostic study or what a radiologist may be saying is existed on the diagnostic study. You want to make sure that that medical professional that's reading it is correlating it to what clinically is being presented on physical examination.
I think one thing to note is sometimes when you're looking at something from the treating side, it's different than an independent medical evaluation. A treating doctor might diagnose everything that's present on a diagnostic study, but not necessarily give you that opinion as to what's related and what isn't. So we don't want to be too broad with the initial acceptance of the injury. So let's talk about some difficult, sort of, I guess you could say, headache definitions of injury that we might see on a case that comes in. Examples of ones that were accepted maybe too broadly from an initial standpoint. One is pain. Pain's subjective. It's difficult to state when someone's fully recovered from pain. They can continue to complain for pain for a long time, and I'm sure many of you are aware of that. Some of these claimants, they know what to say. So pain is also definitely something that you want to stay away from, because there's no objective way to really state whether someone has fully recovered from pain. Some of the hot injuries that we see now that can be difficult to deal with in the future are concussions and post-concussion syndrome. For almost the same reason as pain, many of these diagnoses are based on subjective symptoms.
And let me set the stage here, and when we're talking about acknowledging these injuries and accepting them on a notice of temporary compensation payable or a notice of compensation payable, is whatever the definition of that injury is that you have accepted, at a later point in time, it will be our burden as the employer to show that the claimant has fully recovered from the condition. And an example that Lucas pointed out is when the definition of the injury includes pain, that is a very hard burden to establish through objective criteria for your independent medical examiners that somebody has recovered from having pain. Pain is purely subjective. There is a Commonwealth Court case out there from years ago that indicates that pain can be used as a definition of injury, even though it's really a symptom. But our recommendation is that when you're accepting an injury, using the term pain creates a very high burden that possibly cannot be overcome at a later date. So we ask you to shy away from accepting pain as a diagnosis on your bureau forms when you're acknowledging an injury. Concussions and post-concussion syndrome, we see very frequently somebody hits their head at work and automatically someone jumps to the conclusion that this must be a concussion. This is another type of condition that is extremely subjective, even in a clinical setting. And often we will hear our medical experts say that it is very difficult on an objective basis to disprove that somebody has post-concussion syndrome. And so that should be another diagnosis which we shy away from accepting at the onset of the claim. And we're going to talk in a little bit about what happens when you initially accept, possibly in a case of a head injury, just a contusion to the head, but then it later, turns out that it is actually a concussion. we'll cover that of how to handle that. But in general, within those first 21 days, you want to be accepting the more general term of just a head injury or a contusion, rather than jumping to the conclusion that there is a concussion or post-concussion syndrome.
How about post-traumatic stress disorder? Have you seen plenty of those?
You see that very frequently. Usually later in a case, but again, post-traumatic stress disorder, and kind of, you'll hear this common recurring thing, that is another condition which is very difficult objectively to disprove or to show that somebody has recovered from. We don't see it a whole lot within the first 21 days of an injury that somebody would be diagnosed with post-traumatic stress disorder. But I have seen that in some cases as an accepted injury, and it just makes it extremely difficult at a later date to disprove it or show that it has recovered.
And of course, one of the other problematic ones when we see initial acceptances of herniations, as we discussed before, a diagnostic study is only a snapshot in time. We don't know when that herniation actually occurred. It can be degenerative in nature. It can be something that could have pre-existed the date of injury. So it's always difficult to accept or it's difficult when we are dealing with an accepted herniation and then having to disprove it, essentially.
Correct. Again, in to kind of dovetail into that is, you will also hear a difference between a radiologist interpreting it to an orthopedist interpreting it. Very many times radiologists will be accused of, quote, overreading a diagnostic study, and in looking at the picture indicate that they believe there's a herniation present. The orthopedic surgeon or neurosurgeon may then review the same picture but clinically indicate that they don't think that there's a herniation present, that it's a sprain strain. And again, if we accept a hernia or a herniation as part of that initial work injury, it is very difficult to disprove it at a later point.
So on low back injuries or cervical injuries, I guess the best thing to do, you go to sprain strain until you are certain as to whether it's actually related, if you find a herniation on a diagnostic study.
Correct. Within the first 21 days, it's always better to stay with that sprain strain rather than indicate that you're accepting a herniation or an aggravation of the underlying degenerative conditions.
Okay, and of course we do see plenty of degenerative conditions normally sought later on in litigation via the claimant. Degenerative joint disease, degenerative disc disease, of course, an aggravation of a pre-existing condition, is a new injury in Pennsylvania, which can create problems when we have such a broad description of injury, when you have an aggravation of a degenerative condition. So the description of injury is also important in terms of what treatment is going to be related to the injury. Do you see cases where there's problems with surgery?
Yes, so in practice, we typically recommend accepting that more general term of a sprain strain. Does that mean that as the case develops and diagnostic studies come in and it turns out, let's use the example of a shoulder, that you accept initially a shoulder sprain strain, but as the diagnostic studies come in, it appears that there is a rotator cuff tear. It is not good practice to simply look at your notice of compensation payable or notice of temporary compensation payable in a box and simply say, well, because we only accepted the sprain strain, even though the case and the injury later developed into a rotator cuff tear, that we're going to deny the surgical bills. There is very broad case law in Pennsylvania dealing with this issue, and what the courts have said is that a carrier or employer runs the risk of being assessed penalties if they deny treatment for a body part which has been accepted. And so when we're reviewing medical bills and we're looking at whether or not to pay those medical bills, that should be the first question that we ask is it related to the body part which we have acknowledged, not necessarily is it only related to that diagnosis of a sprain, strain, or a tear?
And we do have some other options for challenging injury aside from whether it's related. Of course, there's the utilization review process, which, depending on the case, might not be a bad thing to undergo if you have a challenging surgery that's coming up.
Right. So if there's certain treatment that is related to the body part, which is always the first question we're going to ask, it most likely would be deemed compensable. But if it seems that that treatment is excessive or other conservative measures have not initially been taken, then the avenue would be to file a utilization review to challenge the reasonableness and necessity.
So we have some ways of agreeing to change the description of injury. Sometimes we'll see carriers will issue amended notices of compensation payable, indicating a broader injury when there's no dispute that there is a more significant injury than, say, a sprain strain involved. Another avenue is a supplemental agreement, which would be an agreement with the claimant that there is a more significant injury or an expansion of the injury that's warranted. Do you see both used interchangeably?
More frequently now with the EDI transactions and carriers issuing documents through the EDI transactions, I have seen many more notices of compensation payable that are amended at a later date than previously. Prior to the EDI transactions in Pennsylvania, we manually would complete the notice of compensation payable or temporary notice of compensation payable. And we didn't see it very frequently that there would be amended notices. Pretty much the practice was, even if you accepted a sprain strain, it'd be the onset of the injury, but then later surgery became warranted, claims representatives or employers would go ahead and pay those bills. There wouldn't be a lot of questioning about the description of injury. And we just went about as business as usual. More recently now, because of EDI transactions, I do see more expansive or more refined descriptions of injury being addressed by amended notices of compensation payable.
Then, of course, when we're in the midst of litigation, there's also the option for a stipulation of facts where the parties can agree that way, submit a written stipulation to the judge, specifically indicating an amended description of injury if there's nothing in dispute. And of course, then the judge will issue a decision formalizing the stipulation and the amended description of injury.
Right, and where we see this generally in practice is, typically medical bills that are related to the injury are paid. But if certain bills are denied, often claimants will file a petition for review to formally expand that description of injury. At that point, if there is no defense or you have an independent medical evaluation that the examiner agrees that the diagnosis should be expanded, you can resolve that litigation by a stipulation of facts. And we frequently also see petitions for review filed when the employer takes a step to somehow modify or terminate the claimant's benefits. Very often, if you have a petition for termination, you have an opinion from your independent medical examiner that the injury is limited to a low back strain, and that the injured worker has recovered from that. Very often you will see claimants filing their own petitions to say, one, I'm not recovered from the injury, and two, it's more expansive because it should include an aggravation of degenerative conditions.
So as we discussed, we have independent medical evaluations where you'll call upon a medical expert to assess the status of an accepted case. It's always important when sending your cover letter to your independent medical evaluator that you advise of the proper description of injury so they know essentially what, if they're assessing a full recovery opinion, what the extent of the injury is that it's accepted that they're saying the claim is fully recovered from.
And that is very important, and it's one of the things that we frequently see of cases that go into litigation is at the initial onset example of the case where there is the definition of the accepted injury is an aggravation of pre-existing degenerative condition. And an independent medical examiner then is called upon to render an opinion, and that independent medical examiner comes back and says, I believe that the injury was limited to a sprain strain and the injured worker has recovered, that medical opinion will not hold up in litigation simply because the medical examiner did not recognize what the accepted injury is. And there is case law that says if the examiner does not recognize what the legally accepted injury is, their opinion is incompetent and cannot support a petition for termination.
And then, of course, we can also use the evaluation as a means to limit the description of injury, as we already stated. If you have something like a herniation or a more severe injury that's involved that may appear on a diagnostic study, you can advise your independent medical evaluator to assess whether that's something that's related.
Yes, and to go back to the cover letter that you mentioned, and when you're advising your experts in independent medical evaluations, in cases such as a petition for a review, you want to tell that expert specifically the diagnoses that the claimant is alleging occurred. You want to say, Dr. Smith, the claimant is alleging that not only has we accepted a low back sprain, but also alleging a herniated disc. You want to ask that expert very pointedly, do you believe that the work injury resulted in a herniated disc? When you ask those types of pointed questions of your independent medical examiners, you get better results in being able to specifically define that injury.
And essentially, you want your expert to take an investigative approach when reviewing the description of injury or what's going on medically in a case. You don't want them to take the perspective of a treating physician where they don't have that direction as to the background of what's accepted, what isn't, where they might inadvertently or accidentally pick up a greater description of injury than you may be expecting. And then, of course, from the independent medical evaluation, we can have full recovery opinions where a doctor will issue an affidavit of recovery indicating the specific description of injury from which the claimant has recovered. In that event, it would most likely be the accepted description of injury. And sometimes we have work-related injuries, your doctor will indicate work restrictions. We want to make sure those restrictions are actually restrictions that are stemming from the work injury itself. I recently had a case where it was an older gentleman who had quite a few outside issues, cardiovascular issues, and I received a report from an expert stating that, well, in terms of the injury, he didn't really assess what the restrictions were. However, he said because of these blatantly unrelated cardiovascular issues that the claimant couldn't return to work. However, upon clarification, he said that the restrictions in terms of the non-related causes were differentiated, and then we were able to obtain work restrictions that were specifically related to the accepted injury and work with it from there. So as we already discussed, that the claimant's method for expanding the description of injury would be a petition to review. The claimant would file the petition to review with the workers' compensation judge, and would be the claimant's burden of proof to show that that the condition that they're alleging is in fact work-related. And as we stated before, it's pretty common to see these following an employer petition, such as a petition to suspend, especially a petition to terminate, because you might be saying, well, the claimant's injury is limited to a sprained strain from which he's fully recovered, and then the claimant's strategy is quite often to say, well, listen, my injury is greater than a sprained strain, and I'm still treating for this expansive injury, such as an aggravation of degenerative disc disease or degenerative joint disease. That's something that we'll frequently say, where we'll have to have our expert then differentiate the accepted injury from the alleged injury and explain why these degenerative conditions may have been pre-existing the specific injury. So with a petition to review, there are certain instances where that deal with timing. There's a statute of limitations where the claimant must file the petition to review to expand the description of injury within 3 years of the most recent payment. It's not something we encounter too often, is that right?
You don't see that issue very often in litigation. It does come up from time to time, and typically that's because in practice, what you see happening is that carriers and employers follow the rule that if medical treatment is for the body part that has been accepted, those medical bills are paid, and we don't really focus on the specific definition of the injury as a sprain, strain versus a tear. So we don't often see that. There have been some cases in the past where individuals, waited, beyond the 3-year period for filing a petition for review, but in most cases you're going to see that filed while the person is actively treating.
And another bar to potentially expanding the description of injuries when the claimant may have known about a condition that was related to the injury that they did not bring to light in prior litigation. It's known as the Winey or Waney case, where a claim then later on would be barred by res judicata or collateral estoppel.
Right. And with that, a couple points is because notices of compensation payable and notices of temporary compensation payable are unilaterally issued, the injured workers don't necessarily have a say in what we accept. Once it reaches the level of litigation, basically under the Waney test or the Waney series of cases, what the courts have said is if the injured worker is in litigation, it's their burden to raise the issue of description of injury the very first time you're in litigation. What happened in Waney was there was a round of litigation. That litigation ended by a stipulation and agreement by the parties, and then there was a subsequent round of litigation where the injured worker then alleged, well, my injuries were broader than what we acknowledged during the first round of litigation. The courts ultimately have said that you're barred from bringing a subsequent action. If you don't raise the issue of description of injury in the first round of litigation, you can't bring it up at a later date. One other point that I wanted to make, because it's a frequent question we have regarding the payments and the 3 years. Payment of medical bills in Pennsylvania under our rules of evidence is not an admission of liability. So if you pay medical bills related to a rotator cuff tear, but you do not actually formally amend the notice of compensation payable, the payment of those medical bills, technically under the rules of evidence, does not mean that you have accepted the rotator cuff tear. Now, in mediations and in discussions with judges, they have said that they will take a look at that type of evidence. In other words, if you have been paying bills for a period of, to exaggerate it, for 20 years for somebody's lumbar disc herniation, I think it's going to be harder to convince a judge that the injury was only limited to a sprain strain. If it's in the short term, then it should not be problematic. But technically, under the rules of evidence, payment of those medical bills is not an admission of liability.
Of course, the employer also has the option of filing a petition to review, although not done fairly often, as long as we limit our descriptions of injury from the onset of a case to correct a material mistake of fact or law that was made at the time the notice of compensation payable was issued. There have been cases that have discussed that this is not a way of getting out of accepting an injury that you just failed to research or investigate at the onset of the work injury. And there's this case involving a heart attack where the employer stated that they didn't have all the records available, yet they accepted it anyway, and it was problematic in then trying to disprove that the acceptance of the work injury. In fact, it was precluded.
It is very difficult once you accept a broader type injury, such as a herniated disc in the low back. Do you have the ability to go back and correct that by filing a petition for review? Yes, but it is extremely difficult.
So when it comes to litigation and the amendment of a description of injury, say the claimant files a petition to review alleging an injury greater than what was initially accepted, if that issue goes to a decision, the description of injury would be amended via a judge's decision. We see this come up as in petitions to terminate, as we said, petitions to suspend. We'll see claimants file petitions to review. One difficult thing can be you might have accepted a sprain strain, but if the claimant, and maybe you've proven that the claimant fully recovered from the work injury itself, however, that work injury was then expanded by the judge. If a claimant prevails in whole or in part, the claimant would be entitled to litigation costs. So sometimes it does make sense if you know that there's something that's greater than a sprain strain to accept it, or agree earlier on to a greater description of injury to avoid the litigation aspect cost of it. Is there strategic?
Correct. If there's a petition for review that is filed and it's a case that you have the evidence that shows it's more than a sprain strain, in a lot of cases you want to voluntarily amend that, because to litigate it you end up with one, like you noted, having to reimburse litigation costs if the injured worker prevails in whole or part. But also, you can be assessed penalties and unreasonable contest fees in that context.
And the judge also has the option of sua sponte expansion of the description of injury based on the evidence that's before him or her during the time of litigation. If the evidence is there to establish a description of injury, the judge on his or her own measure can go and expand the description of injury beyond what was initially accepted absent a petition to review.
Correct. That the judge can address description of injury at any time without a formal petition having been filed by the injured worker.
So finally, we'll end with settlement and the description of injury, where most claims will end as well. Of course, cases settle via a compromise and release agreement. And when we're just discussing specifically the description of injury, there's a section there, a paragraph on the very first page, where you'll list or have a way of delineating the nature of the injury. It's always best to include all the injuries that are accepted and how they were accepted, but most importantly, what we always recommend is to include an any and all provision or clause that's going to resolve any injury that the claimant may have sustained during his or her tenure with the employer. That prevents issues where, say, if we're just talking the same body part, it can be fairly obvious, but you never know if you have other injuries out there that someone may have not mentioned to their attorney or just never really brought to light. In terms of settling all injuries that are out there, a compromise and release allows for that by including any and all language.
And I just did want to note that we do always recommend using any and all language in order to incorporate any possible injury that happened or could have happened or may have happened. There are more recently some workers' compensation judges that will not approve that language in an agreement because they believe that it should be specific to what has been accepted, and that they don't like broad language that an injured worker is giving up any and all rights to any injury which may have occurred. But we deal with those on a case-by-case basis.
Right, that would be an issue that you'd want to discuss with your attorney based on the particular judge you're in front of.
Correct.
Well, we're nearing the end of our session here, so thank you for attending our webinar, Defining Injuries in Pennsylvania Workers' Compensation Cases. Our next program will be on December 19th from our New Jersey office, entitled Top 10 New Jersey Workers' Compensation Cases of 2017. Our New Jersey attorneys will review the most important decisions impacting New Jersey workers' compensation law issued by the courts and state legislature in 2017. This will include precedent-setting holdings issued by judges of the Workers' Compensation Court and decisions by the Appellate Division of the Superior Court. We will also cover any important amendments to the Workers' Compensation Statute. Our discussion will include an analysis of these critical decisions with any impact on the administration of benefits, practice of law before the Division of Workers' Compensation. You can learn more about this program and all of our Weber Gallagher events, again, at www.wglaw.com/wg-university. And thanks for joining us today.